I hope that this is working now. I have to completely start over because I had a glitch, internet issues, and good evening. Hopefully this is working now. I had to start everything all over, set it up. Had a glitch, which is the software I used to go live up now, and I see this one here. Could you let me know if you can hear me? Sometimes 6 o'clock happens to be when a lot of people get on the internet. I used to do it at 5, and that was even worse. Hi there. Okay. Hi, MJ or Marin. I forgot what you said I could call you. Can you hear me? Well, I see that you're there, but I don't know if you can hear me. I typed a chat. Can you hear me? And for some reason it's going because I don't see screen. This is frustrating. Frustrating. Yeah, so it seems to be working, I think. Okay, so I had done question number 21, but I'm going to do it again because I had to start all over. So I wanted to see if, yes, okay, my volume is working. All right, number 321, this has to do with legal land use, legal descriptions, and contract law. So a legal description of a property is one which A, accurately identifies the boundaries of the property as distinct from all other properties. B, accurately describes the location and dimensions of the lot and improvements of the property on the property. C, is accepted by a licensed surveyor as suitable for inclusions in a survey of the property. Or D, is written by an attorney licensed to practice real estate law. We're doing national. We're continuing with national. The answer is A. A legal description identifies every single individual property. It has its own identity. So it accurately, A, identifies the boundaries of the property as distinct from all other properties. So I'm trying to post my answers and they are not showing. I don't know why. So the answer is 321A. Number 22. The essential elements of the meets and bounds system are A. Shoot, going the wrong way. A. Parallels, baselines, and meridians. B, boundaries, distances, and a baseline. C, so this meets and bounds is used like with acreage out in the county. So the answer for 322 is C. And my answers don't seem to be showing when I type them on there. Not sure why. Okay. But if you can hear me, please let me know. Okay. So I see it on YouTube. It's lagging the internet connection. Yes. Yes, I can hear you. Oh, wow. It's not showing on my software, but I'm seeing it on YouTube. Okay, excellent. So it's working. It's just not somehow working on my StreamYard video. There is lagging and there are internet issues. Number 23. In the rectangular survey system, a range is the area in between what? A, any rows of sections in two consecutive meridians. C, a principal meridian and a baseline. D, a parallel and a meridian. So review the rectangular survey system. You may or may not have a question on the exam, but you want to be prepared. So the range is the area in between what? The answer here is B, two consecutive meridians. So 323 is B, two consecutive meridians. Its relationship to the principal meridian. All ranges are 6 miles wide. So the meridian goes up and down, and the range goes east and west. So it's wide. Ranges are wide. Yes, on YouTube, I can see the answers, but not on my software. Okay, number 24. And maybe I can show you an example of a meridian or the rectangular system so that you have an idea. Rectangular survey system. If you see that wheel of in Apple computers, when out in the county, method of land description developed in 1785 to divide land into a grid of 6 mile principal meridians, north and south, and baselines east and west. So you can see it here. Let's see if it enlarges it. So it provides precise, uniform legal descriptions for real estate, primarily covering the Midwest, West, and unmuted again. So lots of crazy things are happening tonight. My apologies. So in the rectangular survey system, a tier is defined by A, 6 consecutive sections of a township, B, 2 consecutive medians, C, 2 consecutive parallels, or D, a parallel and a meridian. So number 24. So when they say a tier is defined by 2 consecutive meridians. B. Number 25. In a rectangular system, survey system, what are the dimensions of a township? A, 1 mile square, or B, 6 miles by 6 miles, which is 6 miles square, or D, the north and south boundaries are 1 mile apart. The east and west boundaries are indeterminable. So I mentioned just a moment ago that it was what, 6 miles by 6 miles, and it has 36 by 1 mile. So you have 6 sections that go east and west, 6 sections that go north, and those 6 going north and south. You multiply that, you get a 36 mile square. 25 is B, 6 miles by 6 miles, or 6 miles square. So when you square that, it becomes 36 sections. So those are all vocabulary that you want to look up. Township, what's the mile square, the meridian, parallel, and the meridian, the range. Those are all vocabulary. Number 36. Oh, here's an interesting, and I was good at it because I liked it. RD 164. So the size in acres of a subsection of a township is a fraction of 640. Since there are 640 acres in a section, and I should probably show you this because otherwise it's really confusing. Okay, I wanted to and by the way, this is Prep Agent, and he does excellent videos that you can watch. So, okay, so yeah. So you see how I was saying you have 6 going east and west and 6 going north and south. So this center square, you have 36 sections, starting with section 1, starting from the left. I'm sorry, starting from the right, 1, 2, 3, 4, 5, 6. The outer uh, is just showing you a square picture of the outer area. So it starts 1 through 6, then it goes down 7 through 12, down 13 through 18 until it sections is 640. So it's 1 mile by 1 mile. So the whole township is 6 miles wide, 6 miles deep, and it has 36 sections. So each section, one of these squares here, one section is 640 acres. And then they start dividing it. Let's see if they have any more, into smaller blocks until they come up with this. So 10 acres, 4. So it would be 10 divided by 640. Okay, because it's 10 acres out of 640. So the answer is 164. You drop the 0. Okay, 164. Is the answer there. So the size in acres of a subsection of 40, which then becomes 1/64 of a section. I hope y'all follow it. If not, you'll want to go and study here. Numbers that has 640 acres. So 10 acres divided by 640 gives you the 1/64 by eliminating the zeros. So 326 is D. Okay, because of all these issues, we may cut this class a little bit shorter. Okay. And I'll resume again. Seems like there's a delay. I'm freezing. Okay, the lot and block system of legally describing property is used for A, farm properties, B, any property in an unincorporated area, C, properties where meets and bounds is not acceptable, or D. Okay, so what did I say? Within the city limits, okay, is where lot and block. So like, let's say you're walking, right? And every block has a street name where each lot may have one single home on it, depending on the zoning, whether it's R1, one residence per lot, or multiple homes per one residence lot. So that's where zoning controls the expansion of a city and falls into property. When you go downtown in a town, those will be lot and block. When you go out in the country, then that's going to be meets and bounds using the rectangular land survey system in areas where there's a lot of acreage, because the acreage is not divided into lots. I may be typing some of these answers more than once because I can't see them unless I look at YouTube. Okay, so we're on number 28, correct? Yes. A certain legal description contains the phrase northwesterly along Erie Road to the point of beginning. So every survey starts at one point. It goes all around the land and then comes to the beginning point. So the beginning point and the end point end up being the same. And then they put markers on all the corners. If it's a nice rectangular lot or a square lot, if it starts having curves, then they have to take angles and measurements and more markers, and they start adding percentages to the legal description. So which one do you think it is here? I won't be able to see your answer, so I'm just going to type the answer. So this is a description of C, meets and bounds. So meets and bounds description identifies the point of beginning and describes the distance and direction from that point. Okay, so you start here, you go up here to the beginning to define the property's enclosed perimeter. So the beginning monument marker ends up being the end monument marker until they get around the whole property. So I typed the answer already. Okay, number 29. How many sections are a township? Well, I showed you that just a little bit ago when I mentioned sections, but if you don't understand the concept, then it might be challenging to answer this correctly. So remember, 6 miles by 6 miles. So that'll be what? 36 The answer here is D, 36, 329D, mile by 1 mile. Number 30. In the rectangle contains how many acres? A, 640, B, 320, C, 160, or D, 40? The answer here is 640. Each section contains 640 acres. So that prior answer where it said, what is 10 acres equivalent to? 10 divided by of that section. So since there's 640, then 10 acres is 1/64th of that 640. So 338. Something tangible. C, something of value traded in exchange for something of value. Or D, something of equal value with whatever is received in exchange. So remember, in a contract, buyer and seller agree to a dollar amount. And so there's got to be a consideration, but it does not have to be, I'll give you a clue, it does not have to be money. It can be other things. A consideration in a contract to make something tangible, trading something of value consideration, valuable consideration necessary to make a contract valid must be in addition to signatures. Okay. Something of C, something of value traded in exchange for something of value. Sometimes people trade properties, or they trade a vehicle or a semi or something else instead of cash. So 331 is C. Okay, 32. A real estate sales contract to be enforceable must be what? So this is a must. It must have whichever one of the following is correct. B, be written on a form approved by the State Bar Association. C, be acknowledged by 3 parties. So remember, this section has to do with land use, legal descriptions, and contract law. So a real estate sales contract to be enforceable must have one of the following, A, B, and C. The answer here, because each property has its own identity, is A, contain a legal description of the property. That's how properties are distinguished from one to the other. They don't go by address, because the address could be incorrect or could have been changed, or when acreage was subdivided, addresses changed. So the legal description is the accurate identifier of each property, each single property before subdivision. Once it's subdivided, then each lot is going to have its own legal description. Okay, number 33. Have to accept from the time of the offer or signing of the offer, delivery to the seller. C, within 24 hours following the stated expiration, or D, a reasonable time or until the expiration date of the offer. So 333 is D, a reasonable time or until the expiration date of the offer. Some states give a certain deadline, like you must reply within 24 hours, 48 hours, 12 hours. In Texas, for residential, we don't have an expiration date to the offer. So if the seller never responds, that means they didn't accept it. Okay. It's best to respond. So both parties know, yeah, courtesy of what's going on, whether they, when I was in Oregon, we had an expiration date. Here in Texas, we don't. It's a reasonable time. And we as realtors, we stay on top of that. We don't want it to go forever, right? We did a lot of work to help a seller and a buyer. And our job is to consummate, the sale and purchase of a property and bring it together between the two realtors by meeting with our clients. Okay, number 34. A buyer submits an offer to a seller and then dies in a car accident. Before learning of the buyer's death, the seller accepts the offer. Which of the following is true? Heirs have the option of enforcing the contract. So remember that whenever there's an offer, each party has to be informed. If the person is not alive, then they can't be informed, right? Okay, so MJ said in North Dakota, he thinks it's 24 hours. Yeah, I'm not sure what it is in North Dakota. It'll state it in the offer. There's an expiration date on the offer, on the contract. It could be different. Okay. It comes between, depends on the seller. The seller might want a decision within 24 hours if they're in a rush. And the buyer might counter and say, well, and there's no contract, right? If it's not within the timeline. However, so that was going back to so I can't see here. Won't let me scroll down on YouTube so I can see. Can you go over questions when your national is waived? The buyer's death terminated the offer. Because even though it says a seller, so a buyer submits an offer to a seller and then dies in a car accident. The buyer dies, okay? Before learning of the buyer's death, the seller accepts the offer. But now there's no one to inform about that offer was accepted because the person died. And I'm seeing questions on YouTube, but since okay, here. Let's see. Somebody asked, yeah, it's freezing. Can you go over questions when your national is waived? I don't understand that question, Catherine. So that question was from Catherine Carter. Can you go over questions when your national is waived? Huh. So pretty soon I'll be ending the national and then I'm going to go to Texas. So you'll be able to see the answers on the replay of the YouTube video 24 hours after this session ends. All right, number 35. Which of the following A, an exclusive listing agreement, B, a personal services agreement, C, a contract for the sale of undeveloped land, or D, an employment contract between broker and a salesperson? So which of the following contracts can be assigned to another party? In those contracts, they'll have the name of the buyer and it'll say and or assigned to someone else. So investors or wholesalers will do that. They'll tie up properties and they may already have a buyer. So they're kind of acting like a realtor, but they're not. They're not representing anybody. They are in the position of buying the piece of land and then they find a buyer and they assign it to the buyer. So the answer for 35 is C, a contract for the sale of undeveloped land. So it can be on a house. It doesn't have to be undeveloped land. That's just the correct answer in this case. It could have been on a residential or can sign an exclusive listing agreement. Personal services agreement, that's right. So the only correct answer for 335 is C, a contract for the sale of undeveloped land. But again, as I said, it could be land that's developed. It could be a residence. Okay, so national questions for now. We started with 20. So we've done like 16 questions. And correctly. Okay, so for state questions for Texas, all right, since I am in Texas, we're going to continue with Texas contracts and special topics. Oh, you know what? So today, let's see, Texas questions. Yes, we're starting with 617. Okay, so let me move here. Six 17. So that's on page 421. And then the answers will be on 594. Texas state questions was next. With challenges. I'm sure you are aware that glitches happen with the internet and software. Okay, I think we finished, yes, with number 16. Okay, number 17. Proper notice procedures be followed. In this proceeding, the notice of sale must precede the sale date by A, 7 days, B, 14 days, C, 20 days, or D, 21 days. So this is in Texas. Okay. Non-judicial foreclosures, meaning they don't have to go to court and get the judge approval. That would be a judicial foreclosure. So there's two types of foreclosures. Well, there's others, but the two for properties that one owns is non-judicial, where they don't have to go to the court. The deed of trust explains the process for proceeding with a foreclosure, and the trustee manages that. And then a judicial foreclosure has to be taken to the court and get the approval, a legal proceeding from the judge. So in the state of Texas, how many days do you think it is? The answer is 20. Oops, that's kind of hard. The answer is 21 days. So a lender can start sending a notice, legal proceedings, and require that proper notices be followed, and the notice of sale must precede this days. Typically, it takes longer. The lender can start sending out notices that they are in default. In non-judicial foreclosures, again, they don't have to go to the judge. The foreclosure price called a short sale, or it may be less than market value. Well, a foreclosure won't be a short sale. It'll already be at the courthouse. With that as a given, which of the following is true? So in a non-judicial foreclosure, that means the lender has started the foreclosure proceeding. The foreclosure price may be less than the loan balance, or it may be less than market value. With that as a given, which of the following is true? A, if the foreclosure price is less than market value, the lender may pocket the difference. B, if the foreclosure price is less than market value, the debtor equal to that margin. Or C, if the foreclosure price is less than the loan balance, the creditors must absorb the difference on their books. Or D, if the foreclosure price is less than the loan balance, the creditors have 3 years to recover the difference from the debtor. So the debtor is the borrower, right? So which would be true here? Or it may be less than market value. So the answer here will be B. If the foreclosure price is less than market value, the debtor is entitled to an offset equal to that market margin. Or if it's above the loan balance, then the borrower gets to get the difference of what it sold for after all the expenses, and they may get some back. But if it's below the loan value and below the market value, they may have to pay a difference, a deficiency, to the lender. Okay, where am I here? So here, if the price is less than market, the debtor can get relief. But if the price is less than the debt, the creditors have 2 years to recover the deficiency. Where here it said the creditor has 3 years to recover the deficiency from the debtor. So that's why that one was not correct. A says the foreclosure price is less than the market, the lender may pocket the difference. No. Number 9, in a judicial foreclosure, the court issues a difference following the value. If so, the debtor may obtain an offset for the difference. The window of time is A, 90 days, B, 180 days, C, 1 year, or D, 2 years. So the debtor needs to push to make sure they get that money. If the bank got more than what was owed on the loan. So the answer is 1619A, 90 days. After 90 days, in the absence of a challenge, okay, as I mentioned, the debtor has to go and challenge them. The foreclosure price in a foreclosure sale is the number used to identify any deficiency, if there is a deficiency. All right, number 20. A, obtaining an appraised value that exceeds the mortgage amounts owed. B, getting the buyer to agree to make up for any deficiency. C, getting the lender to provide a full releasing. Or D, reporting the correct amount of debt forgiveness to the IRS. Because when the bank gets a loss, they send it to the IRS as a deficiency. So in a short sale, what the borrower wants to do, the owner of the home, because it's owned by the borrower and not by the lender when it's a short sale. When it's foreclosed, it belongs to the lender, right? It got foreclosed. And so in this case, the borrower wants the lender to provide a full release of the lien at closing, so that they don't have to keep paying whatever balance there was. And 2000 properties. So when I did a short, the lender would forgive any deficiency with a full release, because there was also a 2007 Mortgage Debt Relief Act that the government placed, that if it was a primary residence, the owner debt would be forgiven. Pricing increased in Oregon like crazy, unrealistically, and then the market crashed. A lot of Californians were going to Oregon, buying with cash, and it increased the value of properties artificially. So that eventually crashed. Okay, number 21. According to the Texas Property Code, recording real property conveyances has which of the following legal effects? Recording tells it to a borrower, right? Causes the transaction to be legal and binding on the principals. C, it prevents the transaction from being void with respect to creditors and subsequent buyers. Or D, it enables the buyer to remove all liens on the property. So what's the value of recording real property conveyance? It has what legal effect? Here is 1621C. It prevents a transaction from being void with respect to creditors and subsequent buyers, because sometimes fraudulent individuals try to sell the same property over and over. And if it is not recorded so that it is constructive notice, it's public to everyone, it could happen. And it has happened to some people. Creditors coming after, like credit card debt. With credit card debt, there's no sum for longer than that. Credit card debt, but lenders can demand the deficiency judgment and get the difference. With credit cards, they'll bug you for years. However, there's no collateral, so they cannot come after your home. Credit cards, debtors, other types of department stores, they cannot come after your home. 622, or an owner's home. Okay. An essential distinction between actionable fraud and intentional misrepresentation is that a fraud requires two or more parties to commit, that the misrepresenting party did not realize the statement was untrue. C, misrepresentation. Or D, actionable fraud. So the answer for 1622 is D. Actionable fraud must have resulted in damage to the defrauded party. And now it said here, intentional misrepresentation. So that means that an advertiser, a realtor, a broker, or a lender intentionally misrepresented their business, their service, or whatever they're doing. Fraud, the actual fraud caused damage to the defrauded party. Intentional misrepresentation may have not caused a financial damage or other type of damage. Okay. Okay, how many questions? B, the maker must have a guardian if deemed to be mentally incapable. C, the maker must be 21 years of age. Or D, the will cannot be the maker's own handwriting. So which of the following is an accurate requirement for making a valid will in Texas? The answer is A. The maker may be 17 years old if a member of the military. Because if they're old enough to be recruited or drafted and go to the military, then they're old enough to make a valid will. Having a guardian, no, they would have to have prior to that some type of, right? The maker must be 21 years of age, no. They can be 18 if they're not a member of the military, okay? The will cannot be, it's not an accurate statement because some people do write their will in handwriting and date it and sign it. Number 24, regarding mechanics liens cannot be filed until there is a delinquency in paying the contractors. B, there is a specific 75-day time limit for recording the lien. C, the lien or repaired. Or D, mechanics liens are classified as involuntary in Texas. So number 24, the answer, there is a specific 75-day time limit for recording the lien. So a contractor, electrician, plumber, builder that are contractors and did work for an owner, they'll inform them that if I don't get paid, I'm showing you that I'm going to file a lien. And they have 17 days, okay, for recording that lien. There's specific 75-day time limit. So to that property. So the day that homeowner or whoever the property is gets sold, that lien gets paid. If there's sufficient money, the lien may get paid in full. If there isn't some other judgments and liens, then they'll know because of the registration in underwriting. Okay, so the internet muted me, so hopefully you can hear me now. So let me start over. 625, the overriding purpose of the Veterans Land, dang internet. A, to administer programs designed to assist vets in acquiring their principal residence. B, to partner with Veterans Administration in underwriting low-income housing for veterans. C, to create a forum for appealing reject loan applications, veteran homeowners. So what is the veteran overriding purpose of it? Is A, to administer programs designed to assist vets in acquiring their principal residence. And they can only have one veteran approval. They get a certificate from the VA, and then they send that to the lender that they've been approved by VA. that they can purchase a residence. So they can only do it once. After they sell that one, they can, I think after a certain time, purchase another one using a VA loan. They would, I think, have to get another approval. Okay, number 26, purchase a property in the Silverleaf subdivision, which is managed by contract. B, the seller must disclose the HOA requirement prior to taking possession. Give written notice in the sales contract. So Jane is the buyer, okay? D, it enables the buyer to remove. I would say, nah, it's not going to be that one. So Jane would like to purchase a property that has an HOA. So which of the following is true? A, if Jane is not informed of the HOA prior to closing, Jane can cancel the sales contract. That is the answer. 1626 8. They cover basketball court, gym, not electric. They may pay for trash, water, sewer. And the owner pays for insurance, homeowners insurance, their improvements or their maintenance, depending if it's a subdivision of houses. If it's a condo, maintenance is done by the HOA management company hiring a maintenance person. So, and HOA fee monthly, some are yearly, some are every 6 months. It depends. It depends on what the HOA includes. Which 27, which of the following equitable interest vocabulary? A, following the execution of a sales contract and prior to closing, sellers have an equitable interest in title. B, Texas is referred to a lien theory state. The mortgage company is the mortgagee. The borrower is the mortgagor, right? So which is a true statement regarding equitable interest? The answer here for 27 is D. Texas mortgagor, it's the borrower, holds equitable title in the collateralized. It's a title theory state. So B said we were a lien theory state. Well, it's not. Texas is a title theory state. Legal title transfers to the lender in a mortgage loan. And then there is in the deed, it will say vendor's lien. Once it's paid, the vendor's lien gets removed from the deed. And legal title transfers to the lender in a mortgage loan transaction until the loan is paid, is executed. The buyer, not the seller, acquires equitable title. Here, under certain circumstances, such as default, the buyer can acquire legal title. So equitable title. So the lender keeps the control on that paid for, right? So again, I said the mortgagors, which is the borrower, hold the collateralized property. 1627D. Okay, we survived. My system didn't work as well. However, we survived. The answers are shown complete. So just to show you, this is the book, Texas Real Estate License Exam. That was updated after the contracts changed and after the NAR, National Association of Realtors lawsuits. So this has updated information when it deals to Texas law. Okay, any questions? Since I can't see them on here and I can't see them very clearly on YouTube, let me see if there's any comments. I have to enlarge my screen. It's taking a little bit of time. Okay. Oh, there. We started the Texas state questions and answers. Okay, well, thank you for your patience with all the glitches and the internet interruption. And hopefully either tomorrow or next week, Tuesday, Wednesday, and Thursday is when I'm doing these sessions or these classes or reviews at 6 p.m. Central Standard Time. So Eastern Time is 7 o'clock. Western Time would be 4 o'clock, right? The two of and my, so thank you very much for joining us tonight and participating somewhat in because it was challenging tonight. And this review, we completed, I think, all the tests for Texas. And typically what I do, questions that you're like, oh my gosh, I didn't study that. I've never seen that before. Well, they're designed to help a problem solver have common sense. Okay, if no questions, thank you so much. Love y'all. If you're getting ready to take the exam, remember to say, I passed, I passed, I passed. Until